Good evening and welcome to the premiere episode of Know Your Rights, the show where you will hear directly from lawyers who will break down the law and explain the rights of citizens on common legal challenges that confront Belizeans on a daily basis. The first topic of our show today is money lending and pawn shops. History shows that money lenders have been around from as early as 500 BC. The principle back then to present day remains the same. Loans advanced to persons short of cash and for emergencies. The first moneylender in Belize dates back to the early 1990s, and today there are 85 countrywide. Unlike banks and credit unions, you can borrow from a pawn shop with less hassle. You receive a price for your item being pawned, and you have a certain amount of time to pay off your debt and claim back your item. If you can't make the payments, then your item becomes the property of the pawn shop. Money lending and pawn shops are both legitimate businesses regulated by the government. But as in all businesses, there are those who are law-abiding and those who seek to take advantage of customers. If you know your rights, you are less likely to be taken advantage of. Tonight, in our premiere episode, we are very pleased to have Ms. Vanessa Retreage, former Attorney General and law partner at Reyes and Retreage, to share information on tonight's topic. Good evening and welcome, Ms. Retreage.
Thank you, Khadija. Good night, everyone at home listening to us, and thank you for having me.
Thank you for being here. We basically want to start, especially for our viewers who may not be very familiar with the procedure of going to institutions such as pawn shops and money lending agencies. What is it they would expect walking into a place and needing to borrow money?
Well, as the introduction that you read suggested, you simply walk into the pawn shop, and there are two types of borrowing. You can borrow with security, so that you walk in with maybe a piece of jewelry, perhaps a car, television, something that gives security for the lending, and that's called pawnbroking, or simply just borrowing money without security, which is simple money lending.
Okay, and I think the question everybody wants to tackle first when it comes to borrowing money is interest rates. What kind of interest rates we could expect from money lenders and pawn shops?
Right, so the legislation currently does not prescribe an interest rate, but what it does say is that if you apply to the court has the power to deem as harsh and unconscionable loans where interest greater than 48% per annum or 4% per month is charged. But what is important for people to know at home is that it's not only interest rates that are attached to loans. Money lenders have also the ability to charge fees, other fees and charges relating to their administrative expenses that they have in giving these loans. So that in addition to interest rates, there is the ability, and it's permitted by law, for money lenders to also put on additional fees.
Okay, so make we back up a little bit.
Sure.
One of the more common ones is submitting to the pawn shop or the money lender an item that is valuable to them, a collateral. Now, when I take in my collateral, what is the evaluation process in place? How do they deem how valuable this item is to me, or how should they?
Right, and that's a good question, because it's important for people to appreciate in this context that money lenders are taking risk, and so they would look at the item that you bring in and determine. It doesn't matter if in your estimation, or even if you have a receipt which says, I bought a TV for $1,300 yesterday, so I came to pawn it out. You can't expect to be given $1,300 because the moneylender has to assess the risk with advancing you money, and so the money that he will advance you will naturally be less than the value that you attribute to your item.
As any lending institution would, I mean, even if you've got a bank or you've got a credit union, but what you're saying is that you could take in something where you actually have the receipt, maybe one gold chain or something, and it's valued at $1,000 or $1,300, and they still make basically a subjective guesstimate of how much this is worth,
right, and
what they give you.
Exactly, and they determine what they will give you. Now, what they will give you based on the item you bring in is not the value of the item. It is just reflective of the risk that that moneylender is going to take in accepting that item as security for the loan.
And I want to go back to the administrative fees because even starting out this interview, the first thing I tell you, make we start with interest rates because that is usually the question asked. But you're saying that the interest rate is actually set in stone by the regulation, 4% per month. So that's 48% per annum. So no pawn shop, no money lender who is licensed by the state should be charging anybody more than this 4% per month?
4% per month on the loan, the initial loan, because it has to be, I must emphasize that the law does provide, let's say for instance, you borrow money and your monthly payment, your weekly payment is $20. If you miss that weekly payment, then the moneylender is allowed to charge interest, simple interest, on that sum that you miss. So 4% on $20, they can charge that. But they can't, let's say, increase the interest rate on the entire loan. So if you miss the payment and the interest rate was 4% per month, if you miss one payment, they can't automatically say, from this date, your interest rate increases to 15% per month because I am implying and I am putting on a default interest rate. They cannot do that.
So would they tell the public no pawn shop, no money lender has the right to jack up your rates for any reason?
Just because you default, no,
just because you default payment. And these rates, pretty high. I mean, 4% per month is a high amount of money. But these loans, what are the timing? I guess we have to look on the time span. Of
the legislation doesn't provide for a maximum and a minimum, but generally speaking, within the money lending business, it's usually short-term loans. And so the 48% interest rate per annum may seem high, but people don't generally borrow for that extended period of time. And I'm sure if it is a borrowing for that extended period of time, there is room for a person borrowing to negotiate with that money lender for a reduced interest rate for that extended period of time.
And from the legal perspective, you would say negotiation is pretty important because first we talk about the collateral and the value. And I was quite surprised when I discovered that you can actually take in a receipt for something and prove to them that I think you undervalue my item, and they still have the freedom to tell you, well, no, I'm only giving you such and such. How important is this period of negotiating a value set to your item from the beginning of the agreement?
It's important because just as money lenders take risk, persons have to know what value they ascribe to their item. So that I would suggest that if you go into the pawn shop and you have that leverage to negotiate, because in many instances there's not the leverage to negotiate because you simply need the cash. But if you have the leverage to negotiate and maybe in the contract that you sign for money lending, for borrowing the money, try and insist that we agree that the value for this item is placed at this specific amount, so that in the event that the pawn shop has to sell that item, there's a value that's put in a contract that the item, you can't sell the item for less than this value. But like I said, negotiation powers depend on what your specific bargaining power is, and if you need the cash, it would be very difficult for you to negotiate and bargain with a moneylender in that way.
I like how you touch on the situational aspect of the negotiation, in that you said that it's not all the time that people feel they have the power to negotiate with the moneylender, because in your experience, I'm sure they're in very desperate states when they need to go to agencies like these to acquire money.
Right. And so if you don't, like you said, there are 85 pawn shops countrywide. In Belize City, there's a high concentration. So if you don't get what you're looking for at one, don't be afraid to shop around and see what the best deal is for you, but you have that power to negotiate and insist on certain things.
It's interesting because whenever we refer to these agencies, and that's why I think it was important for us to highlight that it is legitimate business and it is regulated by the law, many people feel that these may be informal agencies and that they don't have as much power, or they can exercise rights for when dealing with institutions like these. But I would just want to highlight the act that you keep referencing, which would be the Moneylenders Act of 2000. And there was also an amendment earlier this year. I would like for you to speak to the transitioning between the Moneylenders Act and the amendment so that our viewers can understand.
Right, so there has been a money lending act in existence, I think, since the early 90s or 80s, and the late 80s or early 90s. And in 2017, in February 2017 of this year, an amendment to that legislation was passed. And the purpose of that amendment, as the head note in the legislation would state, is to enhance a supervisory process in relation to money lenders. Because before, prior to the amendment, the Ministry of Finance was in charge of supervising, if you will, money lending in Belize. But because that ministry was so overburdened with other responsibilities, the supervisory role really fell off the wagon. And so the central bank has now taken up the mantle, and there are stricter requirements for being licensed as a money lender. And there's also more importance being placed on adherence to money laundering legislation and ensuring that that stricter regulation regime is applied also to money lending business. And so it's not an informal business at all. It's really formal, regulated by the central bank.
Regulated by the central bank. So you felt that originally the regulation was not executed as strongly as it could be?
I wouldn't say that it was not executed as strongly as it would be. What I would say is that there were provisions in law that were not enforced in the way that they should be. So that you still had to apply to the Ministry of Finance as a money lender for a license to be a money lender in Belize, and it still fell under a licensing regime, but it wasn't, there wasn't an active supervisory role being taken. Now the situation is going to be different with the central bank taking the place as a supervisor and regulator of that business sector now.
Okay, and we will get into more of these amendments, as well as we will explore a very recent case which occurred in February 2017, February of this year. But we have to take a short commercial break. We'll be right back.
As a smart business person, you're always looking for ways to minimize waste and increase efficiency. Enter Track Solution, a company that provides fleet management services with the latest in GPS technology. Track Solutions fleet management tools give you up-to-date information that allows you to assess and improve the use of your company's vehicles. Using Track Solution, you can ensure that your vehicles are always used safely, efficiently, and effectively, as well as minimize wear and fuel expense. With Track Solutions GPS Tracker, you can check in with your vehicles from any computer with an internet connection. Through its Google Maps connected technology, you can determine in real time your vehicle's location and whether they're maintaining the schedule vital to meeting your company's growing needs. Track Solution will also decrease your company's driver and vehicle-related paperwork and act as an anti-theft device. You'll also receive regular reports through Track Solution's easy-to-use online system or mobile application. Track Solution. Track what matters.
The road to becoming a mother may be a little challenging. Months and months of planning to welcome your little ray of sunshine. You go here and there to gather everything you need for the big day. Here at Blossom, we make the road a little shorter and less complicated. We're your one-stop store that provides you with maternity clothes, nursing essentials, organic diapers and baby supplies, baby clothing, and so much more. We're located at number 2 North Front Street. Blossom, maternity and children.
When me down and me feeling lonely, you make me feel so high. When you chill and you rush and you touch me, You make me wanna fly. Look how you're pretty and brown. You're strong and your heart need ice for cool down. But me no mind if you want give me bun. Me nah talk to your baby. Me a talk to the rum. My rum, old master, are you alone? I lock down the tongue. Long time now. Me a talk to the rum. My rum, old master, are you alone? I bring all the fun. Long time now.
Hi, and welcome back to Know Your Rights. Just a note for the viewer, we invite you to join in the conversation by posting your comments or questions on our Facebook page or by emailing us at info@colorblind.bz. All right, so Vanessa, we were discussing money lenders and pawn shops, and I'm excited about this segment because we actually get an opportunity to get into a real life case and a very recent case, a case that occurred in February 2017. And the case was termed a precedent-setting judgment for the whole world of money lending and pawn shops. And to give the viewers an overview of the case, the claimant, who in this case was the borrower, received 2 loans from a money lender, and the total value was $3,500. For collateral, they put up 30.4 acres of land, and it was agreed in the case, in the agreement between the borrower and the lender, that the interest would be at 4% per month, and in any case of default, this would be increased to 10% per month. We just want quick comments on that case.
Well, firstly, one of the things that the judge found in that case was that the contract, under the current legislation and the law, every money lending, if you go to a money lender, you're required to sign a contract, and it states as a mandatory requirement that that contract shall state all the terms of the agreement between the borrower and the money lender. So one of the things that the judge found in this case, and that contract has to be signed by the borrower. This contract was not signed by the borrower. So the judge found that that was a major difficulty and it did not comply with the provisions of the Act. The second thing is the contract did not state what the interest rate is.
Okay.
It did not state what the interest rate was on borrowing, but it just stated simply it was for a period of 40 days, I believe it was, right?
Yes.
So it didn't state what that interest rate was, but what was admitted by the money lender was that when the person defaulted, the interest rate increased to 10% per month. So that there was the assumption made that it was a 4% and then increased to 10% per month.
And in legal language, when lawyers say state, we mean in a black and white. It was not written in black and white on the contract that it was 4% with a default interest of 10%.
Right.
It was just
remember,
verbally agreed.
As we discussed in the first segment, you cannot have a default interest rate. You cannot increase the interest rate if there's a default. And so that was one of the major things that the court pronounced on, that is in clear violation of the provisions of the Act, and you cannot increase as a default interest rate when people default on their payments.
And this case actually occurred a couple days before the amendment was made, so it was a default on the original Moneylenders Act.
Right, but in terms of amendment, those sections of the Act that speak to provision of interest rate and default interest rate remain the same, so those weren't amended. So the ruling in this case can still be used to interpret those provisions of the Act because those have not been changed.
And earlier, just hearing the case from a layperson's perspective, I mean, this woman, she submitted to the moneylenders 30 acres of land, and I've come to understand not just any land, cane farm land, and for receiving $3,500 loan from the lender, and for this she had to pay 4%, and in any default 10%. Now that's a high value collateral. You used a term earlier where you said that under the law there is speculation for the contract or the agreement being harsh. would this apply in this instance?
I don't know that it would apply because, as I indicated before, this is the risk that a moneylender takes. And risk is not determined only by, okay, I'm safe because this collateral is worth so much.
Okay.
It is also determined by a borrower's ability to even repay, because even though the loan was so small in this instance, the borrower only made 2 payments and defaulted in the rest. And it's important for people to understand that the court did not say that either taking the land as collateral was harsh and unconscionable, or the actual enforcement taking the land if the person doesn't pay. What made this situation untenable in the eyes of the court was that there was no contract setting out for that borrower precisely what were the terms of the transaction. And the court indicated that it is mandatory that that contract be in writing because that's for the protection of the borrower, and it's so fundamental to any situation that if you don't satisfy that minimum requirement, the contract cannot be enforced. Now, I also want to make a very significant point here. Not because a contract is unenforceable, it means you don't owe the money.
Okay.
It means that if I have an agreement and the court says for whatever reason that those terms of that agreement cannot be applied to whatever arrangement you have,
Yes.
it does not mean that you did not borrow my money. It still means that you borrowed my money. It just means that that contract that we had that stipulated how you would pay me back and when, the court says is unenforceable. So you can't, what the moneylender did in this case is they brought a claim for unjust enrichment. So we won't go by the terms of the contract, since you say that is unenforceable.
And you said unjust enrichment, but I need you to expand on that.
What that is you unjustly get enriched because of me. You got money because of me. You got richer because of me, and it's unjust because I get nothing back for it. And so that is what the court indicated. This case, I haven't seen a follow-up to it, but there are still submissions outstanding for those aspects of it, whether or not the moneylender is able to recover on those grounds. So I will wait to see what the court will decide, but the court hasn't made any definitive finding in relation to that, because certainly I could appreciate how that argument can be made, because it doesn't change that you got my money and used it, and I was deprived of the use of my money.
Yes, I think that is very important that you bring out that we have to be fair to the lender as well.
Exactly.
You need to give the money lender, the pawn shop, their due. They're taking on this responsibility, they're taking on this risk, and it's not only a factor of the collateral or how valuable this item is to you.
Yes.
It is the business that you're in, it is the lending business.
And so for you to say, well, I will take your money and rely on a technicality in the law not to pay you back. The law doesn't operate in that way to allow you to become enriched off someone else's back. And so the law will make provision for protection of the moneylender as well.
Do you believe the amendments assist in further enforcing the protection of both parties?
Yes, I think so. I think because there will be better regulations passed in relation to the fees and other charges that moneylenders can impose, because before the law just provided that you can, and so it varied across the board. There were no regulations as to what would be the limit. I know that there has been a move for the central bank drafting regulations to impose what the limits on those fines could be. Not fines, but fees and charges and expenses, even legal fees in some instances the law provides for. So the central bank can make provision for that. There's also stricter regulations in terms of who could be a moneylender, who could apply for a license, and it introduces the concept of a fit and proper person. And that is defined in law as being somebody who is honest and has integrity and that sort of thing. So there are greater requirements. It's not just you just open a shop and you start. This loan shark phenomenon where people who are unlicensed show up at construction sites and offer loans, that's not legal, and so I wouldn't advise that persons borrow from these loan sharks
people.
because they need a money lending license.
And I'm glad you touched upon the who, because we were actually just going to get into that. And it's funny you mentioned these people hanging around on the construction sites, and I didn't know that it was so common even in the workplaces, bosses offering these loans to employees, and they are not licensed persons. How entering into a relationship, a financial relationship with these persons, does the law provide any protection for the borrower in that instance?
Well, I would advise you not, if somebody does not have the money lending license, I would advise not to borrow money from that person. Just don't use that person. There are many pawn shops who are licensed, many money lenders who are licensed. So why take the risk of not having the protection of the supervisor, the central bank, or the protection of the courts? Because the contract wouldn't be enforceable if you go the route of borrowing from a loan shark.
And we spoke about how they are legitimate business, but they're only legitimate business if they're identified under the law.
If they're licensed under the law to conduct that sort of business.
Correct. And we see now how the law controls and regulates these businesses, even though we may believe that they are a bit informal. And in that sense, go to somebody who is licensed, go to somebody who is legitimate from the beginning. There are so many, better you do that. And I just want to go in here for a segment from the case itself, and I want you to just put it in understandable words. It says, it is only in circumstances where there is an enforceable contract that the court could be stirred to exercise its statutory discretionary powers to grant aid to the borrowers. I just want you to explain what that means, because it was a very important highlight from the existing case.
Right, so under the current law, not only money lenders could access the court. Borrowers can also go to the court and say, listen, I need you to give me some relief because I feel that this money lender has breached the law in some way, has charged me some fees not to charge, has enforced on security in a way that it's not supposed to. So I need you, court, to assist me. What that section of the judgment is saying is that if the court has determined that the contract is not enforceable, as in this case, then the court cannot use the provisions of the Money Lending Act, which says that the court is empowered to give you relief. So you must have an enforceable contract to be entitled to relief under the Act. And so as a borrower, you have to be vigilant and ensure that you get your contract in writing, you sign that contract, and it states all the terms of the borrowing.
The terms, I just want to briefly highlight the terms. You need to say a date on any document you're signing. You need to have your signature up there. What else we need to see up there?
The interest rate that you're borrowing, the length of time that the loan is due for, what happens in the event of default. So the essential terms of a contract should be in that document.
Okay, thank you, Vanessa. We just have to go to one more short break, and then we'll be right back.
As a smart business person, you're always looking for ways to minimize waste and increase efficiency. Enter Track Solution, a company that provides fleet management services with the latest in GPS technology. Track Solution's fleet management tools give you up-to-date information that allows you to assess and improve the use of your company's vehicles. Using Track Solution, you can ensure that your vehicles are always used safely, efficiently, and effectively, as well as minimize wear and fuel expense. With Track Solution's GPS tracker, you can check in with your vehicles from any computer with an internet connection. Through its Google Maps connected technology, you can determine in real time your vehicle's location and whether they're maintaining the schedule vital to meeting your company's growing needs. Track Solution will also decrease your company's driver and vehicle-related paperwork and act as an anti-theft device. You'll also receive regular reports through Track Solution's easy-to-use online system or mobile application. Track Solution. Track what matters.
When me down and me feeling lonely, you make me feel so high. When you chill and you rush and you touch me, You make me wanna fly. Look how you're pretty and brown. You're strong and your heart need ice for cool down. But me no mind if you want give me bun. Me nah talk to your baby. Me a talk to the rum. My rum, old master, are you alone? I lock down the tongue. Long time now. Me a talk to the rum. My rum, old master, are you alone? I bring all the fun. Long time now.
The road to becoming a mother may be a little challenging. Months and months of planning to welcome your little ray of sunshine. You go here and there to gather everything you need for the big day. Here at Blossom, we make the road a little shorter and less complicated. We're your one-stop store that provides you with maternity clothes, nursing essentials, organic diapers and baby supplies, baby clothing, and so much more. We're located at number 2 North Front Street. Blossom, maternity and children.
Welcome back to Know Your Rights. I'm here with Vanessa Retreage, and we're discussing moneylenders and pawn shops. And I got an interesting comment when I was speaking to a couple of people about money lending and pawn shops, that they recognize the importance of these agencies in the community, but that it can also act as a medium for crime, in that it is a way for thieves to wash the items that they stole. What would be your comments to this, and how do the pawn shops and money lenders try and deter this from happening?
Well, I'm very glad that you raised that. I don't know that currently there is anything that requires them, the pawn shops, to keep any specific record, but for their own safety, what the pawn shops do is get IDs from the people that bring in items.
Okay.
Now, under the new regulations, there is a proposal to require pawn shops to keep a detailed record of when an item is received, who brings it in, the ID of that person, when it is sold, who they sell it to, the ID of the person to whom it is sold, so that it sort of creates a tracking for that item.
It's
and
traceable.
And there is a person to connect to that item from the time it enters the pawn shop to the time it leaves.
Okay.
So I think that the regulations as they're crafted now in that regard makes provision for that.
It makes it, but in your advice, do we need more? For instance, we see in America, pawn shops would receive an item and they're actually stipulated by the law not to sell this item before a certain period of time, just in case it's stolen, and to give it a leeway period for the item to be reported by the actual owner and police to come and find it.
I think that so long as there's an effective system of tracking that item, as I indicated before, by taking the full information of who brings it in, who is the person that's responsible for that item when it's at the pawn shop, and when it leaves, who it goes to. So long as that pawn shop owner keeps that information and allow for tracking, I don't know that I see the need for that pause period where a broker is not able to sell an item for that period. But it may be something that the regulator would want to consider for, I don't know what the policy reasons are in the state, so maybe the regulators here would consider whether or not those same policy reasons would apply here and see fit to amend the legislation in that way if
But in your
to.
opinion, documented traceability is pretty good.
Yes, it's good.
And you spoke earlier on how the powers, the supervisory, the control, and the execution of the regulations were transferred from the Ministry of Finance to the central bank, a unit under the central bank. Are these capabilities now such policies to put in place under the jurisdiction of the central bank?
Yes, I think that the central bank, because they already act as regulators for banks, they have some supervisory function over credit unions. So I think it will fall within what they are already doing. And so it would just be another aspect of their regulatory powers and supervisory powers.
We focused a lot on the lenders, and but in some instances you would also be representing borrowers. What would you say to the critics who tell your clients as the borrower, you're the one who sort of put yourself in that position, in these contracts, in these very one-sided contracts, you would say, and now you kind of run to the law for try help you get out of something you put your own self in?
Well, to anybody who would make that comment, I would say that the law is not there to protect one person as opposed to another. The law is there to protect all parties. And so just because a borrower has found themselves in a desperate situation, it doesn't mean that a moneylender can take advantage of that person. That borrower needs to be vigilant, and the moneylender also needs to be vigilant in terms of ensuring that the things that are required in the contract are there for their own protection.
Well, Vanessa, thank you, and we'll make it through the first show.
Thank you for having me.
So we have come to the end of our show for tonight. Thank you, Vanessa, for joining us and providing so much information on tonight's topic. I'm sure viewers learned a lot about their rights and much more. Know Your Rights will be back next week, Monday at 8 p.m., not 8:30, 8 p.m., with Attorney General Honorable Michael Perfeet, who will be breaking down the recent amendment to the law affecting marijuana use in Belize. Thank you for watching, and see you next week, Monday, for another episode of Know Your Rights. Good night.
Yes,
Yes, sir.